The unsealing of a search warrant that was submitted to a federal magistrate judge in support of searching the Fulton County Election Records Office to seize almost 700 boxes of 2020 election records. That search warrant affidavit that's been unsealed now, it really shows the flaws in our system of justice right now. Now, the way this works is usually a law enforcement person, in this case, FBI agent, swears out the warrant, meaning is going to do an affidavit under oath that gives the basis to the judge, in this case a magistrate judge, as to why there's essentially a probable cause that this warrant should be granted. That's what the Constitution requires. Now, as usual, the agent relies on his personal observations and experience. That's sort of boilerplate language. But if you look at what was this observation that he's relying upon, it turns out to be basically him repeating, maybe he was listening to an election denier who Trump put in charge of election integrity spout these kinds of assertions. A guy named Kurt Olson, who was someone that Trump talked to on January 6th trying to overturn the 2020 election. Olson's now the director of election security and integrity, whatever that means. Now, that guy's assertions are actually put in the sworn affidavit as to supply the judge with some of the evidence that this warrant should be approved. Kind of very different than the agent personally observing a crime, right? He's just hearing this from someone else. Now, sure, it's hearsay. That's not really an issue. You're allowed to have hearsay for that. But for him to say under oath that this evidence is based on his personal observations and experience, if you really think about that beyond the boilerplate, like, what does that mean? His personal observation of having somebody, make these assertions to him and his experience in what? I mean, if he were applying his experience in election fraud, if he has that kind of background, he would know that the number of election fraud cases are tiny, tiny, and have never been large enough to change the outcome of any election. It's just a joke. Not really sure what observation he's relying upon, and not sure of what experience he's drawing upon. Also of interest, the statutes of limitations for any of the alleged crime, the election interference, there's some issue about the board not having kept the electronic scans long enough afterwards, even though they had paper records of the voting records. Those statutes of limitations, the period under which you have to bring a charge, are gone. So it seems really hard to understand how the government could prove to a judge that there was a substantial likelihood that a crime had occurred and that evidence of that crime could be found at the location for the warrant. Bit of a tree falls in the forest kind of question, right? If you can no longer prosecute it, is it still a crime? So why did the federal magistrate judge approve this kind of nonsense?